My name is Randy Barnett. I am a law professor here at Georgetown Law. For those of you who don't know me, I also am the faculty director of the Georgetown Center for the Constitution. And I'm here to welcome you on behalf of the center to the annual Salmon Chase Distinguished Lecture. And this lecture series was the very first activity that the Georgetown Center for the Constitution ever undertook. And so I just want to read you a list of our previous lecturers and the topics. Because the Georgetown Center for the Constitution, one of our missions is to, and it's reflected in this lecture, is to celebrate important dates in our constitutional history, as well as to elevate the profile of people who we think have been unjustly neglected in our constitutional history. Tonight's lecture is clearly in the latter of these two, but you'll see from the topics that we've had that we go both ways. In 2014, which was our inaugural lecture, James Oakes gave our inaugural lecture celebrating the 150th anniversary of Salmon Chase to be Chief Justice of the United States, and the lecture series was named after Chase. In 2015, Eric Foner gave a lecture on the 150th anniversary of the 13th Amendment, abolishing slavery. In 2016, Colleen Sheehan celebrated with us the 225th anniversary of the adoption of the Bill of Rights. In 2017, Bill Ewald celebrated the career and the much neglected career and accomplishments of the founder, James Wilson. In 2018, Charles McCurdy gave a lecture commemorating the 150th anniversary of the publication of Thomas Cooley's important treatise, Constitutional Limitations, also an opportunity to celebrate the neglected Thomas Cooley. In 2019, Sandy Levinson celebrated the 200th anniversary of McCulloch versus Maryland. And finally, last year, Martha Jones gave a lecture commemorating the 100th anniversary of the adoption of the 19th Amendment, which gave women the right to vote. Sadly, Martha Jones's lecture had to be conducted on Zoom. The normal venue for us to host this lecture is in the Supreme Court of the United States, which is nice as the Hart Auditorium is, as august as the Hart Auditorium is. It doesn't really compare with the Supreme Court of the United States, but it is better for us to be here in person than it is to do it in another program on Zoom. So we're very grateful that circumstances allowed us to do it. It's my role. Next role is to introduce the person who will represent the Supreme Court Historical Society in introducing our speaker tonight. And the person who will do this is Paul Clement. Paul Clement, for those of you who don't know, and I'm sure everybody does, is a partner in the DC office of Kirkland and Ellis. He served as the 43rd Solicitor General of the United States from June 2005 to June 2008. He has argued over 100 cases before the United States Supreme Court. Paul attended Georgetown University's Walsh School of Foreign Service and Harvard Law School. Following law school, he clerked for Judge Lawrence Silberman on the U.S. Court of Appeals for the D.C. Circuit. Paul is also a distinguished lecturer in law at Georgetown University, where he has taught in a variety of capacities since 1998, and his seminars are always very highly in demand. He also serves as a senior fellow for the Law Center's Supreme Court Institute. He argued the NFIB versus Sebelius case, which I think he will say is maybe his most stressful experience as an oral advocate. But of course, I think he would say that the highlight of his advocacy as a Supreme Court advocate was when he argued the medical marijuana case of Gonzalez versus Raich against me in my only appearance. He has 100 appearances. I have 1 appearance. But I'm sure that he will tell you that that was the one that worried him the most. I will say, I mean, he did win the case 6-3, but by getting 3 votes, I do believe we beat the spread. At any rate, Paul Clement.
So thank you, Randy. It's a delight to be here on behalf of the Supreme Court Historical Society. I'll say just as a note to kind of commend Georgetown and Randy's project and the good work they've done with these lectures over the years. I recently filed a brief in the Supreme Court that cited both James Wilson and the Cooley treatise. So, to the extent that it matters that people are citing the works that you've sort of celebrated in these lectures, the work is making real progress. In all events, it is delightful for me to be here tonight to introduce the Dean on behalf of the Supreme Court Historical Society. I know the Society has long valued its partnership with the Georgetown Center for the Constitution, and it really is hard to believe that this is already the 8th of these lectures. It's my pleasure here to introduce my Dean, William Traynor. Introducing the Dean at his own law school seems like a variant of bringing coals to Newcastle, but I'm going to give it a try. Dean Traynor has a PhD in history from Harvard University, a JD from Yale Law School, and a BA from Yale College, summa cum laude. Following law school, he was law clerk to the Honorable James L. Oakes of the U.S. Court of Appeals for the Second Circuit. Before coming to Georgetown, the Dean was the Dean and Paul Fuller Professor at the Fordham Law School, where he began teaching in 1991. Bill is currently the Executive Vice President and Dean of the Law Center here at Georgetown University and holds the center's Paul Regis Dean Leadership Chair Professorship. That is all a long way of saying that Bill is the rare trifecta of superb leader, teacher, and scholar. And his extraordinary leadership at the Law Center, especially during the last 2 turbulent years with the pandemic, is deeply appreciated and valued by everyone in the Law Center community. Dean Traynor joined Georgetown in 2010 and was reappointed to serve a 3rd term beginning July 1st, 2020. He is not quite Dean for life, but he's working on it, and he has brought great leadership and continuity to the Law Center. The Dean has faced a number of difficult decisions in his tenure, including whether to keep me on as a part-time employee, and I am grateful for his good judgment in that matter and so many others. Recognition for his leadership has been widespread. The Dean has been recognized by the National Law Journal as a champion because of his work to uphold the profession's core values. He received the David Stoner Uncommon Counselor Award for his efforts to raise mental health awareness among law students. And National Jurist magazine has named him one of the most influential people in legal education 4 times. But despite his many administrative responsibilities, Bill remains at heart a teacher and a scholar, as we shall all get to see in a minute. Since coming to Georgetown, he has continued his commitment to teaching and has been in the classroom for a first-year legal justice seminar, an upper-level course on the drafting of the United States Constitution, and most recently, leadership courses as well. His writings have principally been in the area of constitutional history, and he's been recognized as one of the 10 most cited legal history scholars in the United States by the University of Chicago Law School's Brian Leader. His early work largely focused on the history of the constitutional protections of private property. His 1995 article in the Columbia Law Review article entitled "The Original Understandings of the Takings Clause and the Political Process" was recently recognized by the Land Use Professor's blog as the most cited land use article of the past 30 years. His more recent work, including Judicial Review Before Marbury, his doctoral dissertation, has focused on the emergence of judicial review and on constitutional interpretation in the early republic. His work has appeared in the law reviews of the University of Chicago, Cornell, Columbia, Fordham, the University of Michigan, the University of Pennsylvania, Yale, Stanford, and most importantly, Georgetown. And no less impressively, he has been cited twice in the Supreme Court in opinions. His numerous contributions to legal scholarship and education were recognized in his recent election to the American Academy of Arts and Sciences for Law and Education. I know from talking to faculty members who have heard an earlier version of tonight's speech that we are all in for a real treat, so please join me in welcoming the Dean.
Well, thank you, Paul. That was really terrific. And it's a real honor to be introduced by you. So thank you. And it's a real honor to be part of this program. I remember when Professor Barnett and I talked about the Center for the Constitution probably about 10 years ago. And I thought it would be such an extraordinary voice for the study of the Constitution. And but it has surpassed what I thought even possible. And I knew that he was a great scholar and really, such a forceful and thoughtful advocate for the Constitution. But what you've done is amazing. And it's a privilege to be here. This has been really a remarkable series. And as Randy said, it has had two themes. One is kind of great moments in constitutional law, and the other is people who've been forgotten but shouldn't have been. And as he said, today is the latter. But I actually did a Google search this afternoon for forgotten founder. And there are a whole series of books on various people who are the Constitution forgotten founders. So you've got another decade of Luther Martin, George Mason, Charles Pinckney. So, for those of you who are used to going to these, it's going to be a great decade ahead. There's a lot to work with. But Gouverneur Morris is the one who really should not be forgotten. And that's really, what this talk is about. So it's about Gouverneur Morris. So let's see if we can get to the first slide. There we are. Okay. So Gouverneur Morris. So this is Gouverneur Morris is, as I face the screen on the left, he's seated. And on the right is Robert Morris. So they were very close. Gouverneur Morris and Robert Morris were business partners during the Revolutionary War. Robert Morris, who was kind of the Jeff Bezos of the 1780s, was as close as the United States had to a president during the Revolutionary War. He was the head of finance. Gouverneur Morris was his number two. And this is a picture of the two of them together. And this is really the standard picture of Gouverneur Morris. What I'm going to be talking about today is Morris's work on the Committee of Style. Okay, so Federal Constitutional Convention, 4 months. As it's drawing to close, it's hot. Everybody's tired. It has been 4 weeks since they had a draft of the Constitution, which was done by the Committee of Detail. Votes up, votes down. There's no document as the convention is drawing to a close. So a committee is put together, the Committee of Style and Arrangement, and over 3 days, they draft the Constitution, with Morris, as I'll be talking about, as the lead drafter. And then very hurriedly, the convention reviews it, almost completely adopts it, and goes home. The work of the commission is supposed to be polishing the Constitution, kind of taking what's already been agreed to and putting it in a final document. But what I argue in a recently published article in the Michigan Law Review, and the subject of this talk, is that Morris made, as the drafter on the Committee of Style, he makes 15 substantive changes. And as you'll see, most of them are very subtle, but they have incredible consequence. And particularly at a time in which so much, really 4 members of the court are textualists and focused on the original meaning of the words. The words he picked had particular substantive ends, some of which we've lost with the passage of time. But if we're going to read the Constitution clearly, and as it was meant at the time, it's about recovering the meaning of the text that on 15 occasions he changed. So right now I'm giving you the overview of the talk. So one part of this is about the changes he made. And there were a number of kind of basic things that Gouverneur Morris tried to do in the Constitutional Convention. A lot of them he lost before he became the drafter. He was a big government person. He was probably, with the possible exception of Alexander Hamilton, the strongest nationalist at the convention. He was a big protector of private property. He was a champion of the judiciary and judicial review. And he was unquestionably the fiercest opponent of slavery. And he was with James Wilson, who has also been the subject of one of Professor Barnett's series, is also the big champion of the presidency. And in each of those areas, he makes very subtle changes to advance his goals. And if you read the text the way, as the words originally meant, you'll see, how it follows with his meanings, what he wanted to achieve. So that's one part of the text, or of this talk. And the other is, so it's about how Morris created a Federalist Constitution. So Federalist as opposed to kind of Jeffersonian Republican. So that's one part. And then the other part that I'll be talking about is how that meaning was lost. In some sense, this is about how the Federalists won the battle for text and then lost the battle for original meaning. Okay, so that's what this talk is. And again, Gouverneur Morris is on the left, and he's been, almost completely forgotten. So this is just one story. So I was at the National Archives before the pandemic, and they had an exhibit on the Constitution. And they had a little thing on Gouverneur Morris and said, Gouverneur Morris on the Committee of Detail drafted the Constitution. Obvious mistake. Committee of Style, not Committee of Detail. So, so I thought, I can go over and get somebody from the archives and correct this obvious error, but, I'm sure they're getting this all the time. So I don't want to come across as a nerd. So I said nothing and just left. 2 months later, I come back to the National Archives, and would you believe it? Nobody has corrected the error. So there happened to be a senior official at the archives, and I ran over and I said, I'm sure you're on top of this, but I just want to let you know that where it says Gouverneur Morris drafted the Constitution on the Committee of Detail, it was actually the Committee of Style, right? So the senior official at the archivist, I actually haven't gone back to check whether it's been done because I'm afraid of being dispirited, said, oh, we will of course change that. And then the person said, but I have to say, this is not my period. And I don't know who Gouverneur Morris is. And the person then said, and if you go to the National Archives, there's this great mural above the Constitution of these are the people in Philadelphia. And the senior officials of the National Archives said, I have no idea who Gouverneur Morris is. For all I know, and the person pointed up at the mural, he could even be the guy with the peg leg. And I said, as it would happen, and I want to just show you our, oops, dropped. Oh, try. This is Gouverneur Morris. This is the Center for the Constitution's official bobblehead. He has a peg leg. So, okay, I'm just going to put him here so you don't see the, are you going to, could you, okay, thank you very much, Professor Barnett. Shows the problem with show and tell. So anyway, so he's been unjustly forgotten. I think he is actually, and that's what I'm going to be talking about, that he's really the central person in the drafting the Constitution. Now, who does, to the extent that your person in the street thinks about it, who does everybody think is the drafter of the Constitution? Who does everybody think is the father of the Constitution? James Madison. James Madison. And so much of originalism right now, because people think of James Madison as the father of the Constitution, is really a fight for Madison's legacy, right? So this is, of course, the Federalist Society's classic James Madison tie. which I think it's $60, and it's quite attractive. But it's not just conservatives who claim the Madisonian logo legacy. This is actually, people don't remember this, but when the American Constitution Society started 20 years ago, and this is an article about it, started with our own Professor Peter Rubin, who's now on the bench. The liberal alternative to the Federalist Society was called, now it's called the American Constitutional Society. It was originally called the Madison Society, right? So there's a real struggle on both left and right for Madison's legacy, right? And, why do we think of Madison as the father of the Constitution? It's because, we have a standard story, which Madison really told, right? So Madison at Montpelier, nation's falling apart, 1786, 87, he thinks deep thoughts about what the Constitution should be. He gets Washington. He convinces Washington to come to the Federal Constitutional Convention when Washington is really reluctant to do that. Then the Virginians are the first ones at the Federal Constitutional Convention. Everybody else is late. And so the Virginians seize the moment. They come up with the Virginia Plan, which then alters what the Constitutional Convention is about. It becomes no longer about reworking the Articles of Confederation, which was what it was supposed to be. It becomes this new document. The Virginia Plan becomes the starting point, right? And then, you have the two big debates about big state, small state, where you have a compromise. And then you have a debate about is representation based on freed people or freed people and enslaved people? Compromise, 3/5 compromise. But Madison is kind of the genius of the convention, right? He's the one who leads the thought. He's there, he's taking notes, but he's driving the dialogue, even though he doesn't always win. He then, in the Federalist Papers, is even more than Hamilton, the brilliant conceptualizer of the Constitution, with Federalist 10 as the core of what the Constitution is about. He writes the Bill of Rights. And he then, argues for his vision in the Congress. He eventually becomes president. And at the end of the day, his notes, post-mortem, are published. And that's how we understand the Constitution, right? So the way in which we think about the Constitution is really Madison's story, right? And what I'm going to talk about is, important ways in which that's not right or that's incomplete. So let me just start with kind of the first part in which it's incomplete. So this is Robert Morris's house, which is really nice, right? Again, he's the Jeff Bezos of 1787, incredibly rich. Washington, when he's in Philadelphia during the Revolutionary War, always stays with Robert Morris. And I think that it's probably because his house is really nice. But it's also, and this is something, we don't think about with Washington. We think of Washington as part of kind of the Virginia planter aristocracy. And he is, and he owns hundreds of enslaved people. But at the same time, it's striking that he's not a buddy-buddy person, but actually his closest relationships are not with Randolph, the governor of Virginia, Randolph or Jefferson or Madison, people who are very literally to the manor born. They are in a society of primogeniture. They are all firstborns. Okay. Washington, and we forget this, Washington is not the firstborn. Washington is a child of his father's second marriage. And so in Virginia, at a society based on primogeniture, Washington, as compelling as he is, so I mean, he's an extraordinary, he's 6'4", which is, he's a giant, he's a great horseman, he's immensely strong, but he's not going very far because he's from the second family, right? He almost joins the British Navy as a young man because his prospects are so limited. He comes to own Mount Vernon because by the time he's 29, his father has died young. His older brother, who he worships, has died young. And his 4 nieces and nephews have died. So you get a sense of how far he was along the chain of inheritance before he inherited Mount Vernon. And so he had really spent his childhood with all of his talents as an outsider with his nose pressed against the glass looking in. And so the ties that he has, the strongest personal ties, are not with a Jefferson or a Madison or a Randolph, who are all to the manor born. They're with the Northerners who have, really come from nothing, or who are like him, people who are not firstborns who make it on their own. So, and one of them, one who he's kind of very close to, is Robert Morris, who's illegitimate, who's a very successful person, but is raised by his grandmother. And I think Washington has a kind of kinship with him that he doesn't have with the Virginians. And so whenever he comes to Philadelphia, he stays until 1783. He stays with Robert Morris, and then he stops. And he stops because of the Newberg Conspiracy. So this is a picture of the Newberg Conspiracy representation. So at the end of the Revolutionary War, the soldiers have not been paid. Congress has said that they will give pensions, but the soldiers don't think they actually will honor that commitment. And they gather in Newburgh in the barracks at the base, 500 officers. And they're thinking about, do they seize power to get paid? Washington is not supposed to be in the room as they're meeting. And then all of a sudden, the door swings open. And Washington, in his full uniform, unannounced and unexpected, moves forward and moves to the front of the room. And he speaks, and he gives Washington is not a great speaker, but he gives what I think is his most brilliant speech about the importance of the military yielding to civilian authority. And what has never happened before is he does not have the audience. People are hissing and catcalling. That has never happened to Washington. And then he says, and this is this moment is sometimes called by historians, it's the last temptation of George Washington. Okay, if he had wanted to become king, he has 500 officers there, and they are ready to go. But he gives them a speech about the importance of ceding to the majority, to civilian government. But they're catcalling and booing, and he then says, I have a letter from a member of Congress promising you your pension, and I would like to read it to you. And he reaches into his pocket and he takes out the letter and he holds it. And he can't read it. So then he takes out his reading glasses. So that you can see in the picture, he's wearing his reading glasses. Nobody has ever seen Washington in reading glasses. He's always perfect. Nobody has ever seen him in reading glasses. And he says, I have grown gray in your service. And now I find I have grown blind as well. And that's the end of the mutiny. As you can see in the picture, people start to cry, they sob, they leave by the back door. The potential mutiny has been crushed, but Washington suspects that the Morrises are behind it. He writes, and he's furious. He writes a letter. He says, the financier is behind this. And then he writes a letter, subsequent letter. So no, he said, it's Gouverneur Morris who's behind it. He's furious. And he has had this incredibly close relationship with the two of them. And they are now dead to him. 1783. Somehow, by 1787, they are back. We don't know how. The relationship has been restored. But Madison invites Washington to stay with him at Mrs. House's boarding house. And Washington says yes, does not accept Morris's invitation. And I have to say, it's actually, in some ways, it's kind of touching. Madison he's 5'4", he's under 100 pounds. He's balding, not that that's unattractive. And when he lives in Mrs. House's boarding house, he has fallen in love for the first time in his life with a young woman named Kitty Floyd, and they become engaged. And then she breaks off the engagement, and he is devastated. But he still stays at the boarding house, and he invites Washington to stay with him. Washington procession from Mount Vernon, people cheering him all along the way. He arrives at Mrs. House's boarding house. And who is there? Robert Morris and his servants. And Robert Morris says, I insist you stay with me. And Washington says, okay. And so Robert Morris brings Washington to his house. Now, one thing, Washington is actually, he's a master of theater. And, for example, the speech that I gave you, the Newberg Conspiracy, a lot of historians think it was all scripted, including the bit with the glasses. He knew it in advance. And I think he might very well have planned, as a way to explain why he was staying with Robert Morris, that he would show up and then Robert Morris would show up. But in any case, he stays with Robert Morris, and he spends the entire convention with Robert Morris and Gouverneur Morris. Washington, during the break in the convention proceedings, goes traveling with Gouverneur Morris, and it goes all the way through. In fact, at the last day after the convention concludes, he has breakfast with the two Morrises, and then they escort him outside of Philadelphia. Now, I think this is the most consequential rooming arrangement of all time, right? I mean, there are others that are more amusing. I always wondered, Cole Porter and Dean Acheson were roommates, which I've always thought that was a great. What did they talk about? But George Washington being with the Morrises meant that he was with the Pennsylvanians, not with the Virginians, right? So we normally think, because Madison tells us that that the start of the convention was the Virginia plan, because the Virginians had been meeting. In fact, they had been meeting with each other and with Wilson and Morris all the way through. And so the Virginia plan is actually really much more the Pennsylvania-Virginia plan. And Professor John Mikhail has actually done an interesting study of the text. And the big pro-nationalist text in the Virginia plan, which a lot of historians say is just kind of a placeholder, is actually probably drafted by Wilson, who's a big nationalist. And he's put it in there in order to get nationalism on the table at the very start, right? So this is just an example that continues all the way through of the way in which Morris is central in the way that we don't think about it. You know, Washington comes home at night every night to the Morrises. And again, the Virginia plan is really a Virginia-Pennsylvania plan. So that's where he stays. Now, there are, you know, at the convention, you know, you think about Madison as central. He's not. He talks a lot, but Morris talks more. There are more Morris speeches than Madison speeches, and actually Wilson is third, close behind. And it's actually, that's pretty remarkable because Morris kind of as his is one, we'll talk about it, you know, Madison is a planner and a hard worker. Morris takes 2 weeks off in the middle of the convention to go deal with his business affairs. And yet he still talks more than anybody else, right? He's actually on more committees that are elected by other people than Madison. He has a much better record of success with his motions than Madison. And most important, particularly at a time in which we emphasize textualism, the Constitution is not written by Madison. The two key documents are the Committee of Details draft, which is really, and again, Bill Ewald, who spoke earlier at one of the earlier sessions, has shown this. It's really, it's a tug of war. You can see the handwriting. There basically are, Randolph is responsible for the kind of the states' rights text, and Wilson is responsible for the nationalist text. And the two of them are kind of negotiating through, and the document is their joint work. Wilson wins some, Randolph wins some. And then Morris is the drafter of the Committee of Style report. So this is the Committee of Style report. So this is the broadside, which I have reproduced just to give you a sense of what it looks like. And there are 5 members of the committee: Hamilton, Madison, Rufus King, Johnson. But everybody agrees that the person who actually writes the Constitution is Morris. So Morris writes that document. The Constitution was written by the fingers which write this letter. And James Madison, who by the end of his life, they hate each other. It says, the finish given to the style and arrangement of the Constitution belongs to the pen of Mr. Morris. A better choice could not have been made, as the performance of the task proved. So Wilson, who's not on the committee, seems to have reviewed the text, but everybody agrees that Morris was the drafter. Now, was he an honest drafter? Now, spoiler alert, since I call this Dishonest Scrivener, that's the title of the paper. No. So let me give you an example. So this is the general welfare clause as it comes out of the Committee of Style draft. So again, this is, I blew this up from the broadside, but here is the text that goes into the committee and what goes out. And sorry that my picture spoils some of the text, but the legislature shall have power to lay and collect taxes, imposts and excises, comma, to pay the debts and provide for the common defense and general welfare of the United States. Okay, that's what goes into the committee. What comes out of the Committee of Style is the same, except for, does anybody see what the change is? Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and welfare. Okay. Semicolon instead of a comma. Semicolon instead of a comma. So, and that totally changes the meaning, right? It goes from, you know, why do you have the power to lay and collect taxes, to arguably a separate power to provide for the common defense and general welfare of the United States. What's in the Constitution? It's actually a comma. Why? This man, Roger Sherman of Connecticut. So look at that face. He's angry. You saw the jovial Gouverneur Morris on page 1. Morris has seen a substitution of a semicolon for a comma, and he's mad, right? So he's really, this is, I think, he's the historic, he's really the great proofreader of the Constitution. You all, many of you in law school, you've done blue booking. This is why it matters. He captures, he apparently sees the commas become a semicolon and he gets it changed back. So now, how do we know this? Because Albert Gallatin, who's really kind of the brains of the Republican Party, makes that charge about 10 years after in a debate about the General Welfare Clause in Congress. He says Roger Sherman caught the trick. Now, by this point, Sherman is dead and Gouverneur Morris is in Europe, which he spends about a decade in Europe. So we don't know kind of the backstory. Morris never admits it, but the question is, did he make subtle changes in the Constitution, or was this just, an honest error? Surprisingly, before my article, nobody had ever really looked at that. So Clinton Rossiter, 1787, the Grand Convention, is actually one of the few, actually the only one that I know that really before my article carefully looked at it. And he says Morris was a faithful servant. The changes he made, he didn't make any, he didn't do nothing substantive, nothing substantive. Now, interestingly, we have 4 Supreme Court cases in the past 50 years in which the question before the court has been, do you look at the draft that goes into the Committee of Style, or do you look at the Constitution as actually adopted? And 4 times the Supreme Court has said, oh, no. You look at the draft that went into the Committee of Style, not what was actually adopted. So Powell versus McCormick, Warren is one case. Utah versus Evans, 2002 is the most recent case. Same thing. The court says in 4 cases, don't look at the Constitution that's ratified. Look at the report that went into the Committee of Style, because they were about style and arrangement. So they could not have changed the meaning. The only person who's disagreed with that is Justice Thomas in dissent. Even Justice Scalia voted with the majority on the other cases. Justice Thomas is alone, and he says, I focus on the words of the adopted Constitution. So everybody else has said style and arrangement was supposed to be style and arrangement, so they could not have made any substantive changes. So we look at what had been previously adopted, not the text of the Constitution. And the historians who looked at it have all said, that Morris was an honest broker. So these are the 3 most recent kind of leading constitutional histories. David Stewart says this draft, the Committee of Style, then this is a terrific book. This draft had to be faithful to the convention's actions. Morris could be trusted to do that. In fact, he couldn't. So now, why did I focus? Nobody had ever focused on Gouverneur Morris before me in terms of his work of the Committee of Style. Why did I focus on him? Well, I'm from Morristown, New Jersey. So this is from when I grew up. Morristown, a military capital of the American Revolution. And this is actually fairly modest, because in Morristown, we normally like to think of ourselves as the military capital of the American Revolution. The Army was there 2 years. Nobody else had more than 1 year. So I was focused on Morristown, Morris, as a small child. And then when I was probably about 6, the Gouverneur Morris Inn opened up in Morristown. And I think you can get a sense, this is a newspaper story at the time, the excitement. The Gouverneur Morris Inn is New Jersey's first all-new hotel in a quarter of a century. This was a big deal. Okay, now, somebody caught the comma semicolon difference. Does anybody see a problem with the Gouverneur Morris Inn? It's not spelled the way Gouverneur Morris's name was. So actually, when I got older and I was looking, I thought, oh, I've been interested in Gouverneur Morris, but Gouverneur Morris Inn is not actually named for him. It's named after somebody who was Morris, who was a governor. So, but I then did further research. And what I found out was that actually they had meant to name it after Gouverneur Morris. They had just misspelled his name. And it's actually kind of, if you're in Morristown and you go to the Gouverneur Morrison, that's kind of the brand of the hotel, because the restaurant there is named after Aaron Copland, and they misspelled his name too. So they're pretty consistently on message. So anyway, so that's how I got interested in Gouverneur Morris as a small child, and that's continued. Allison, my long-suffering wife, is here. So I dragged her to the Bronx, which is where Gouverneur Morris is from. This is where he's buried. So she took this picture of me, Gouverneur Morris's tombstone at St. Anne's, which is quite large. And it's actually modest. It says Gouverneur Morris, you can't read it, the penman of the Constitution, in quotes. So I think they should have just embraced it. He was, in fact, the penman. There's no need for quotes about it. Now, what should you know about Gouverneur Morris before we get into kind of his constitutional vision? Couple things. First of all, what do people know about Gouverneur Morris right now? I think the two things that are really kind of what people know about Gouverneur Morris is, first, he was, in the words of Richard Beeman, who's wrote one of the best convention histories, a quote unquote serial philanderer. So if you go into like any of the biographies of Gouverneur Morris, like one is by William Howard Adams, I just looked at it. So he's got, if you look under romances, he has 37 pages. If you look at Committee of Style, no entry. So he's famous for being a serial philanderer. And he's also famous for having a peg leg, except in the National Archives. And the two are linked. So some historians think, and the story that Morris liked to encourage, was that his leg shattered when he jumped out of a second-story window to evade a jealous husband. So the two popular stories about Morris are linked. He is very physically dominant. He's 6'4". So, and think about what that means in a small room. So again, Madison, 5'4", under 100 pounds. Morris is 6'4". So I mean, if you think about it today, that's like 7 feet tall. And the same size as Washington. Now, the reason why I'm particularly focusing on that right now is this is a statue that you might be familiar with of George Washington, right? So this is done by Jean Houdin. It's in the Richmond Capitol, but it's the one that if you go to state parks, actually, if you go to the Capitol, if you go to Independence Hall at Philadelphia, this is the standard Washington statue that, is copied again and again, right? So it's Washington. It's actually not. It's Washington's head. Houdin made a life mask of Washington, but it's Gouverneur Morris's body. Because Morris was ambassador to France when Houdin was doing the statue. And Houdin knew that they were the same size. He was the same size as Washington. So he asked if Morris could be the quote unquote, to use Morris's term, mannequin. And so Morris would go over to Houdin's studio and Houdin would copy him. And this is actually, and again, I don't mean to speak ill of the dead, but it's actually lucky for Washington, because Washington was actually pear-shaped, which is actually good. He was a great horseback rider. He was a great dancer. Having a low center of gravity actually helps for those. It's not so good for a heroic image, right? So this physique of command is Morris's, and Washington was very lucky. So what else do we need to know? Morrisania. So if anybody's from the Bronx, the Morrisania section of the Bronx was his estate. At the same time, as I said, he like Washington was from the second marriage. He didn't inherit this is the family estate. He didn't inherit it. He became a lawyer and a business person. He was very successful, and he bought out his brothers for Morrisania. A couple of other things. He had a gift for friendship. So Washington loved him. After they got over the Newberg Conspiracy, loved him, and Washington didn't love a lot of people. I think he found him very amusing, which he was. He had a great sense of humor. But Morris really he was very convivial. Robert Morris, we talked about, he was very close to. But it continued. He was Hamilton's best friend. Actually, when Hamilton was shot, Betsy Hamilton asked for Gouverneur Morris was the one person who came to his grave, or not to his grave, to his deathbed. And when Robert Morris went bankrupt, as he eventually did, Gouverneur Morris, and he got out of debtor's prison, Gouverneur Morris was the one who provided him a house and an annuity. So he was a wonderful friend, and that ties kind of made him incredibly helpful at the convention, building relationships and getting things done. And he was a genius by everybody's estimation. So, and he's a great speaker. If you read the speeches at the convention, he is brilliant in a way that nobody else is. He's funny, he's emotionally powerful. He's just rhetorically superb in a way that literally nobody else is. So there he is. And he's also not trusted. So this is William Pierce, a Georgia delegate. Mr. Gouverneur Morris is one of those geniuses in whom every species of talent combined to render him conspicuous and flourishing in public debate. He winds his way through all the mazes of rhetoric and throws around such a glare that he charms, captivates, and leads away the senses of all who hear him. Partly he's distrusted because people think of the Newberg Conspiracy and his role in it. It wasn't clear what his role was, but he did encourage it. And then there's also a suspicion, which I think is unwarranted, that he and Robert Morris benefited from their role in the finances of the nation. This is the French embassies. Celebrated lawyer, one of the best, smartest men in the continent, but without morals, and if you believe his enemies, without principles. Everybody says he's without morals. But his enemies add on he's without principles. But he was dazzling. Gouverneur Morris, this is Max Farron, who did the convention notes that you might have. Max Farron put them together, and he wrote kind of one of the best histories. This is 100 years ago. Gouverneur Morris was probably the most brilliant member of the convention. Sharp-witted, startling in his audacity, and with a wonderful command of language, he was admired more than he was trusted. I just want to, the most brilliant member of the convention, this is Farron is really the top constitutional historian. It's not Hamilton. It's not Franklin. It's not Madison. The person who knew the delegates better than any other, Max Farron says, it's Morris. So let me just go through some of the changes he made. This is the preamble. So what goes into the committee is, we the people of the states of New Hampshire, Massachusetts, goes on. We the people of the United States, the most famous part of the Constitution, is Morris's language in the convention. And then all of the ends in the preamble are Morris's. None of them are there when it goes into the Committee of Style. Now, we tend to think about the preamble as maybe a gloss on specific powers that are granted or a rhetorical flourish. Okay. But Morris, who was a master stylist, wrote language that had legal effect at the time. And what we see particularly is, this is Fisher Ames, who was another one of Morris's friends, in arguing for the Bank of the United States' constitutionality, says the preamble justifies it. And actually, if you read through the convention, the debates of the first Congress, first of all, the bank was adopted. You know, most of the members of the House and Senate thought it was constitutional. And most of the ones who speak rely on the preamble. Striking. Again, we don't think of the preamble that way. They did. And if we're looking at original meaning, this is the original meaning. Chisholm versus Georgia. So during the convention, Wilson and Morris worked very closely together. When Wilson is on the Supreme Court in Chisholm versus Georgia, he relies on the preamble as justifying jurisdiction over Georgia. Now, Madison disagrees with that, right? So Madison is not as close a reader of text. So this is the preamble, he says, has produced a new mind of power, right? He's saying the preamble is just a flourish. That's what Madison thinks. But the Federalists win all the big battles of the 1790s, and they rely on the preamble as substantive meaning. The contract clause. This is one of the most striking things. When the contract clause, the one time it's discussed on the floor of the convention, it's voted down. It's voted down. And then it emerges in the Committee of Style draft. Now, two things. One is actually Morris speaks against it on the floor, but I think he looks at it as needing some kind of statute of limitations restriction. But I also wanted the Northwest Ordinance, which is what it's based on, right? Says no interference with or affect private contracts or engagement. Private contracts or engagement. When it comes out of the committee style, first, it's there for the first time. And the word private has been dropped. So as a textual matter, it applies to public contracts. And Hamilton in the Yazoo Purchase, Morris's best friend, says it applies to public contracts. Now, you know, there's kind of people think about now that when Marshall says that the contracts clause applies to public contracts, that he was disregarding the original understanding, because that's actually, to the extent that there's debate during the ratification proceedings, people say, oh, it doesn't apply to public contracts. But Marshall was reading the text. And it was Morris's text, and he wanted it to apply to public contracts. Is judicial review part of the original understanding? You know, Van Alstyne and Bickel, these are kind of the classic studies. No, they say it doesn't. Marbury versus Madison created judicial review out of whole cloth. But Morris was a big supporter of judicial review in the convention. Madison was not. Madison was very ambivalent about judicial review. Morris was a supporter, and then he, in the law of the land clause, changed. It had been the Constitution shall be the supreme law of the several states. He made it the supreme law of the land. And that then became, this is the first judicial review case that justices of the Supreme Court heard, Hayburn's case. In basing judicial review, they say the Constitution is the supreme law of the land. Marbury versus Madison relies on supreme law of the land. So Morris, who's the biggest nationalist at the convention, writes a preamble that nationalists rely on. Morris, a defender of judicial review, changes the law of the several states to the law of the land. And courts rely on that, his text. The judicial vesting clause, he also changes. Now, we don't, the kind of Supreme Court case law is this, you know, we don't have to have lower federal courts. That's the way we read the report. But what he's done is he's created language the judicial review in such inferior courts as the Congress may from time to time ordain and establish. And members of the early Congress rely on the language that he has argued, that he's created, to say lower federal courts are mandatory. You know, the Congress doesn't have the discretion to create them. It has to create them. But, you know, this is an example, again, where the Supreme Court disregards the actual text of the Constitution. This is Prince and Scalia and Prince, Thomas and Patchak versus Zinke. They both say the so-called Madisonian Compromise, which is what Morris was changing, resolved the framers' disagreement by creating lower federal courts by leaving that decision to Congress. Okay. Again, the court looks at the debates. They don't actually look at the text. Couple more examples that I want to give you. This is really fascinating. So you think about, first of all, you think about what's the basis of the Constitution? Article 1, Article 2, Article 3, right? That's a creation of the Committee of Style. What goes in is the Congress is 3 through 9. So Morris wants essentially the 3 branches to be co-equal, 1, 2, 3, right? Then he also, and I want to highlight this, the vesting clauses are different for the House and the Senate. That's Morris's creation. And Morris is a big pro-executive guy. So what goes in, the executive power of the United States shall be vested in a single person. The legislative power shall be vested in Congress, right? What comes out is the executive power shall be vested in the President of the United States. But all legislative power herein granted shall be vested in Congress. He adds herein granted to Article 1, right? And that becomes a huge deal for modern executive power theorizing. Starting with Alexander Hamilton, again, his best friend in the Pacificist debates, which is whether Washington can issue a neutrality proclamation. Hamilton says he can because the president has all executive powers and Congress just has legislative powers herein granted. So Hamilton, Morris's best friend, uses Morris's language to justify expansive presidential power. Morris is the biggest opponent of slavery at the convention, the biggest. And his speeches are so powerful. Domestic slavery was a nefarious institution. It was the curse of heaven in the states where it prevailed. And then in opposing the slave trade, the admission of slaves into the representation, when fairly explained, comes to this, that the inhabitant of Georgia and South Carolina goes to the coast of Africa and in the defiance of the most sacred laws of humanity, tears away his fellow creatures from their dearest connection and damns them to the most cruel bondages. These are the only speeches of any power at the Convention Against Slavery, and they're Morris's. He is deeply opposed to slavery. And he does 2 things on the Committee of Style. First is, this is the Fugitive Slave Clause. He takes out the word justly. So what goes into the committee is enslaved people shall be delivered up to the person justly do their service or labor. He takes out the word justly. And that becomes crucial in the early abolitionist debates. And Sean Mullen spoke at one of Professor Barnett's programs focusing on this. Because he took the word justly out, there's no claim that the Constitution recognizes the morality of slavery. And this is complicated, but I have to say, this is like my favorite. Again, the comma semicolon. So I'm basically, if you think about the 13 first states, depending on how you count them, it's 7-6, 7 north, 6 south. The anti-slavery North has kind of a razor-thin margin. And what states are going to come in next? Vermont, which is the 14th state and has already been separated from New Hampshire or New York, is an independent republic. And in the South, Kentucky and Tennessee. which are actually both part of Virginia and North Carolina. What Morris does here is, and you can look at, if you look at my Michigan Law Review, what he does is he changes the text from nor shall any state be formed from the junction of two or more states or parts thereof without the consent of the legislatures of such states, as well as the legislature of the United States. So basically, if Congress and the home state okay a split, it's okay. 2, no new state shall be formed directed within the jurisdiction of any other state, semicolon, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures concerned as well as of Congress. So what he's saying is here, a state can't be divided, period, or semicolon, right? And he's doing that because he wants Vermont, which is separate, to become a new state, but not Kentucky or Tennessee. Now, this one is so clever that nobody gets it. So Kentucky and Tennessee are admitted, but it's there. Actually, there's a great article by Michael Paulson called "Is West Virginia Unconstitutional?" Which draws on this language to argue that West Virginia is not constitutional because it was split off from Virginia. So his approach to constitutional interpretation is, I can't remember what, this is something he wrote later, can't remember what the debates back and forward were, but look at the words. So he was a textualist before textualist. And why? Because he wrote the text. Now, final point. I have to say, I love this. Teddy Roosevelt. My favorite biography of Gouverneur Morris is by Teddy Roosevelt, who clearly saw a lot of himself in Gouverneur Morris. Aristocratic New Yorkers, not overly worried about what means they took to get the ends they thought important. He wrote a biography of Morris. There's never been an American statement of greater intellect or more brilliant genius. Had he possessed but a little more steadiness and self-control, he would have stood among the 2 or 3 very foremost in American history. Amazing statement. But he actually really captures, so my final point is, so the Federalist reading of the text, I think, is the text, because that's what Morris was. So why, when I've looked at the various texts, have we lost that? And it's because Madison planned, right? He played the long game. He wrote the notes, he pushed for his agenda. Whereas Morris and Wilson, who were the 2 Federalists, we tend to think of, the standard story is, it was about Madison, and Wilson is kind of his wingman, and Morris is just kind of having a good time, a little bobblehead, yeah. But Madison plays the long game. He pushes for his interpretations of the Constitution all the way through. Whereas Wilson is really kind of one of the spectacular flameouts in American history. He's awkward and he wants to be Chief Justice, but Washington doesn't really, he thinks people don't really like him. And so he goes through a whole series of Chief Justices, and it's not Wilson. And Wilson is really devastated because he wants to be a great figure in history. And if he's not Chief Justice, he's not. So he becomes very aggressive in his real estate investment, thinking he could be Jeff Bezos. And so he becomes very aggressive. And at one point, he's one of the 5 richest people in the country while he's on the Supreme Court. But then the Panic of 1796, liquidity crisis, debts are called in, Wilson can't pay. So he actually, as a justice of the Supreme Court riding circuit, is fleeing his debtors. He also marries a teenager. His wife dies, he marries a teenager. And the 2 of them, he dies as she's tending him over a bar in North Carolina. It's not a great story. So, when people say Madison, nobody ever says, Paul, I don't think you ever say Wilson. And that's because it's not a heroic story, right? Morris is actually exactly the opposite. So at the end of the Constitutional Convention, he's really done. So, so Hamilton says to him, I'm thinking of doing a defense of the Constitution. We'll call it the Federalist. Would you be my co-author? Moore's like, no, I'm done. I'm going to be focusing on making money and having a good time. So actually, then Hamilton turns to Madison. So actually, we think about Federalist 10. Madison is the most successful understudy in American history, right? He was the second pick. Hamilton went to Morris first because he was a better writer. But Morris says no. During the ratification debates, the only debates that the only record that we have of Morris is he went to Virginia to watch, and he wrote poetry, making fun of various, people participating in the debate. So the doggerel is his only contribution, nothing in the Federalist Papers. He also stays with one of the Randolphs, and they have a daughter. At the time, Nancy's 17. That's not a great picture of Nancy. As good as the story about Gouverneur Morris is, the story about Nancy is even more interesting. So Nancy is a Randolph, kind of one of the great Randolph families, one of the great families of Virginia. Her mother dies. She's 17. Her sister is a little bit older. Her father remarries. The new wife is 16. She doesn't like having stepchildren who are older than her in the house. So they're kind of pushed out. Nancy and Judith become engaged to cousins. Nancy's fiance dies. So she lives with Judith and Robert, who's her cousin and brother-in-law. And Nancy becomes pregnant. They go to kind of a big event, but she's hiding the pregnancy. They go to a big event at another plantation, a big party. Middle of the night, people hear screams. They go to the room. The brother-in-law locks the door, won't let anybody in. Following morning, people go back. Nancy's in the bedroom. It has been stripped of the bedclothes as if she's given birth. One of the enslaved people walks out behind the mansion, and there's either a fetus or a baby who's been killed. He goes back to get other people. When they come back, the fetus or the body is not there. Robert, the fiance, brother-in-law, was probably the father, and he's tried. He hires John Marshall and Patrick Henry to represent him, so not screwing around. And he's acquitted. Nancy goes back to live with her brother and sister-in-law. 2 years later, he dies. People think, well, maybe it's natural. Maybe Judith poisoned him. Maybe Nancy poisoned him. She continues to live in the house, and then after a few years, Judith kicks her out. Nancy, we don't know how Nancy survives, but she's a pariah in Virginia society. She heads north. And then somehow she meets Morris, who had known her when she was a teenager. And he asks her if she would run his estate, run Morrisania. She says yes. She moves there, and they fall in love. And he decides he wants to marry her. But he's a little worried about the poison thing. So he writes a letter to John Marshall, and he says, I don't want to invade attorney-client privilege, but I know you represented Nancy Randolph, and I'm thinking of marrying her, and would I be misadvised to do so? And Marshall says, no, you can go ahead, marry Nancy. And he does, and at the age of 57, and shortly thereafter, they have a son, Gouverneur Morris I, who's called cut us off as the first by the jealous relatives who've been looking forward to the big Gouverneur Morris inheritance. But That's a picture of Nancy. And when she dies, the son builds a church in the Bronx that is named St. Anne. Her full name was, or actually her proper name was Anne. And that's where Gouverneur Morris is buried. And if you go to the Bronx, it's on St. Anne's and 141st Street. And on the gravestone of Gouverneur Morris, it says, and this is written by Anne, Nancy, "Conjugal affection consecrates this spot where the best of man was laid." And that really captures kind of at the core who Morris was. This is really his motto for life: to try to do good, to avoid evil, little severity for oneself, little indulgence for others. This is the means to obtain some good result out of our poor existence. To love one's friends, to be beloved by them, this is the means to brighten it. So, among a generation that was concerned with their place in history and who dedicated themselves to government and to creating a legacy, Morris was concerned in part with building society, but also with the people he knew and loved. So I think you get a sense of that. That's the picture that we saw. That's the only picture I know of kind of two founders together. Most of them are, all the others are really one after the other. And look at the difference between that, Hamilton, Washington, Madison, and the two Morrises. They're like people from a different movie. The others are kind of off looking towards history and to posterity. And for Morris's, it's about friendship and supporting the people we love. And so that's the sum. Morris crafted the Constitution. He wrote the text that has endured for more than 200 years. But that was not all that he valued. What he valued as well is cherishing the people he loved. So, and the purpose of this talk has been continuing in the Randy tradition of elevating forgotten founders to help you to see Gouverneur Morris where otherwise we would not see him. So thank you all very much.
Well, Bill, that was just spectacular. It was when I heard an earlier version of this speech, this lecture, when you got your chair, the dean chair, that I decided during the course of the lecture that we would dedicate a lecture to Gouverneur Morris. And so, and this lecture, what it has grown into, just exceeded even those very high expectations that I had for this lecture. And you have accomplished something. I think you should feel very proud of yourself, because I think through the dint of your own efforts and your scholarship, you will have successfully revived the memory of one of our most forgotten founder, the drafter, the actual author of the text of the Constitution. So that's, I mean, we can't accomplish that much in our short scholarly careers, but that's a huge, major accomplishment. And even more than that, you do this, you present him with that engaging, winning sense of humor that you have. And it comes through in this lecture just so well. So I just thank you so much for being our 8th Salmon P. Chase lecturer. And it's going to be a hard act for future lecturers to live up to. But you set a standard for us at the center, and you set a standard for us at Georgetown. And I thank all of you for coming and being a part of this today. I thank all of you who may be watching this either live or later on YouTube. And I look forward to next year when we dedicate our lecture to Frederick Douglass and anti-slavery constitutionalism. Thank you all for coming.